Okay. Yeah. So, good evening, my dear friends. I'm Nachiketa Mittal. Some of our friends, my students, my colleagues, lawyers, some of you who would already know me, and there are a lot of other students who have been signing up. So, for them, that I'm a law teacher, and I've started in the month of April earlier this year, a virtual law school, which is a platform not for profit and exclusively for the law students, non-discriminatory in nature, for all kind of law students who are not able to get admitted to top law schools of the country, different NLUs, state leading law schools, and so on and so forth. So it was during the national lockdown that we started a journey, and where we could start with the inaugural lectures by Honorable Justice A.K. Sikri, Honorable Mr. Justice Korean Joseph, then Mr. Siddharth Luthra, Senior Counsel of Supreme Court, and also some of the Vice Chancellors, Professor friends, even Justice Anand Pathak, who is a sitting judge of the MP High Court, and even for the inauguration of the virtual law school, we had all of these, senior members from the bar and the bench, including Mr. Rajiv Luthra. So they all participated even in the inauguration program of the virtual law school, which is a innovative concept of reaching out to all these students. And we ran completely pro bono for good 2 months of the national lockdown, where we could teach 6 days a week and 6 hours a day for 600 law students. And after that, we have come down to the low bono model, where we charge very nominal just to let the organization move on. And at present, we have been teaching like around 20 law subjects with the help of a lot of lawyers, law professors. And I'm very happy to tell you, Mr. Krishnamurthy, that all lawyers and law professors, they all have been teaching completely pro bono. They do not charge anything, and it's 30 hours of the course, which is the regular course of any law school that we teach. And since I've been teaching in National Law University Odisha for last around 8 years, right? So that's part of being my training process of having a very structured course outline and then teaching it through. And it has never been the process that anybody as a lawyer would also teach on a subject just by virtue of a practice. But we have a well-designed syllabus, and that is followed like any other law school would do it. However, there's a factor that we are not a degree-giving institution, and we do not offer any diploma either. So it's certainly not recognized by BCI or UGC, but it's a non-teaching, not-for-profit, just a law teaching initiative. So that's been a journey. And today I am, my dear friends, very happy and honored to welcome Ms. Naina Krishna Murthy, who has been able to spare time of busy corporate life as a founder and managing partner of Krishnamurthy and Company. I've had association with Ms. Naina Krishnamurthy since past some time, even when I was working as a dean of a private law school in Gandhinagar for the last 1 year. So Krishnamurthy and Company was very generous to support the moot court competitions. And today's topic has been very carefully thought of, owing to the expertise and years of experience of Ms. Krishnamurthy about young lawyers and M&A practice in COVID times, because we all understand that during this challenging and crisis time, there are a lot of young lawyers who are undergoing various kinds of trouble in establishing themselves. And to tell you, Ms. Krishnamurthy, a few weeks earlier, we had a program with some other law firm professionals on advising that how can the budding lawyers and some of those who are looking forward to establishing their independent law practice, so what should be the do's and don'ts about it? Should they try to sever their ties from the law firms that they have been working with as their parent organizations, and try to, is this the right time to take that plunge in the market by themselves? Or should they be trying to strengthen the law firms where they have been working for long years? And that kind of patronage will help them sustain through, and is also going to increase and add more value to their law practice. So that's what we have been trying to do even in the past. And I'm happy to tell you that in this series of global legal approaches and development talk, so we have earlier been honored to host Mr. Kapil Sibal, Mr. Prashant Bhushan, Dr. Abhishek Singhvi, Mr. Salman Khurshid, Mr. Yatindra Singh, who is the former Chief Justice of High Court of Chhattisgarh. And also on Sunday, this Sunday, we were happy to host Honorable Mr. Justice Michael Kirby from Australia. And also we had Professor Shanta Kumar, who is the Vice Chancellor of Gujarat National University, who delivered the lectures. And in the coming weeks, on 17th of this month, we will be having Professor Benjamin Davis, who has been the former chair of American Bar Association Dispute Resolution Section and is a professor of law in Toledo School of Law, Toledo University, Ohio. So this has been the journey of the Global Legal Approaches in Development talk so far, and about the virtual law school. And now, my dear friends, without taking much time, I'm happy to introduce our speaker for the day, Ms. Naina Krishna Murthy, who is one of the most formidable legal advisors of the country and has started Krishnamurthy and Company as a law firm based in Mumbai. Ms. Krishnamurthy started her career with Arthur Anderson, followed by a stint as the in-house counsel at Biocon, and founded in 1999 in Bengaluru Krishnamurthy and Company under Naina's leadership and guidance. And it's been a very wide experience of over 24 years that Ms. Krishnamurthy has been specializing in corporate commercial law, especially M&A. That's the reason we have picked up the topic for the day very carefully. Joint venture, collaborations, and investments. And she is also trusted legal advisor to some of the foremost corporates in the country. And some of the companies to which Ms. Krishnamurthy has been advising in all these years include Novartis, Emphasis, McAfee, Software India, GE India, British Telecom, and many others. And along with that, by virtue of being one of the most influential women entrepreneur and lawyers of the country, Ms. Krishnamurthy was also bestowed with Women Leadership for Excellence in Entrepreneurship Award by CMO Asia. So I'm very happy and privileged to welcome you, Ms. Krishnamurthy, for this talk, which is going to be a sort of laying the path for a lot of our young friends that how should they view out of the traditional box that what we teach in a law school in terms of M&A, and some things that they learn by virtue of their internships and in the formative years of legal practice, but you would bring to them completely new insights by virtue of your experience. So we look forward to your lecture. Thank you.
Thank you. Thank you so much, Dr. Nachiketa. Thank you for that introduction, and it's an honor to be here, and honor to be following a list of illustrious peers or seniors in my industry. So I'm very, very honored and privileged to be here, and along with all my fellow students. And I say fellow students because although I've been here, I've been in practice for 24 years. I say that this is a area that you never stop learning, right? Every day is, you learn something. And I think the day you think that you know it all is the day that you stop learning. So, I still consider myself a student. I still learn. I learn from my peers. I learn from my seniors, and I learn a lot from my juniors, right? So that's why I did not make a presentation, because I think it's I would rather talk with, or to the students rather than talk to them, and I hope that at the end of this talk, they will have a little bit more perspective, because M&A as a subject is so vast and so deep and so nuanced, that I don't think that will be a course in itself, Dr. Nachiketa. Maybe one day we can do that, but I think for the purposes of this evening and this talk, I think it's just to give you all a little bit of framework, a little bit of guidance on how to navigate, especially these times. And may I, first of all, congratulate you and really appreciate this platform that you've created for students during these times, because it's people like you who keep the young minds, sort of going forward, and, sort of at least being excited about, and not giving up hope. Right. So so I'm always very grateful for any kind of learning platform, and that has been my passion. So let me just get into this. When we say M&A, I think that first of all, and I know there are a lot of law professors in the audience on this call, but with with a lot of respect to education, and I've done my 5 years of law. When you come and do an M&A in the real world, please forget everything that you've learned in law school, right? Because M&A is all about your commercial sense of what the client needs. One of the first things that I was taught when I started law school, and I'm sure all of you have learned that, is that the greatest acumen of a lawyer, of someone who wants to do law and someone who wants to be a lawyer, the greatest acumen, and now I will say whether it's M&A, whether it's litigation, whatever it is, if you want to practice law, I think the biggest strength or the biggest capability that you need to develop is the ability to filter all the information that you're getting from every direction, bring it down to what is actually required for your client, filter that, analyze that, and deliver that to the client, right? The client is coming to you for your expertise. He's not coming to you to give him a long thesis or theory on the genesis of law and what the statute says and what the regulation says, and more so in a commercial transaction like an M&A. All he wants you to do is help him say, okay, this is what I want to do. This is my objective. Whether I want to sell my company, I want to buy a company, and I'm restricting it to M&As and to selling and buying of companies, because that's what M&A is about finally. I want to sell or I want to purchase. How can I do it, right? How can I do it? How will you help me do that? And that's all the client is interested in. So the one thing that every student has to realize is that don't go and tell your client what the problems are. Don't say, this is the law, but this you cannot do this you can. The client is going to just walk away. He's going to find a lawyer who's going to be more commercially minded. Not to say that you're going to tell him something that is illegal or invalid or that's going to get him into trouble. Absolutely not. But find the solution. Be a solution-oriented lawyer, right? Don't be a lawyer that is going to tell your client, these are the problems. Figure out what the solution is. And I love the practice of law. I mean, I got into this because I love the practice of law. I got into this 24 years ago when law was not a glamorous subject. There was nothing, there was nothing great about doing law, but I got into it because I love the practice of law. And one of the things that I love about it is that it gives you the space to be creative. It gives you the space to have various interpretations to a particular situation, right? It gives you the space to analyze, to figure out, to debate, to discuss. I mean, which area gives you that kind of freedom, the kind of freedom that law gives you, right? So when you have that, you have the ability and the freedom to find a solution for your client. And I think that is the first thing if you want to be a corporate lawyer, right? I mean, let's leave M&A aside for a minute, but if you want to be a corporate lawyer, the thing is to find a solution, be solution oriented. And you're not going to learn that in textbooks, okay? You're not going to learn that in case laws. All that is very, very important. I'm not undermining that for a minute. Please focus on your studies and understand what your teachers are trying to tell you. But what you're going to find that in the real world. You're going to find that in learning. You're going to find that in doing your internships. I think a lot of the training and a lot of the understanding comes in doing your internships. And I'll tell you something. I graduated from National Law School, Bangalore, one of the most premier universities. I graduated in the top 5 percentile of my class. I got the best job in the world at that time. It was the day one job that I got. All of that I did. And I walked into the office and with the chip on my shoulder saying, you know what? I know everything, right? I'm such an amazing lawyer. I know everything. And day one, I was given a lease agreement to review. And I didn't know what to do with it. I didn't know. My conveyancing course in law school did not prepare me, to review a simple lease agreement. I didn't even have the, the knowledge or the understanding to ask my senior, do I review it from the perspective of the lessee or the lessor? Who are we representing, right? Now, these are things that And I can't blame myself when I look at it, because even though law school, National Law School, Bangalore was one of the premier universities that started the internship, this whole concept of internships came from law school, it was still not as sophisticated as it is today, right? So we did internships, but it was, a lot of it was very, very basic, right? And you did not get the kind of training that today a lot of law firms do. There are law firms that, they,
I think we have lost the link, my dear friends. But yeah, stay tuned. So Ms. Krishnamurthy will be just rejoining.
sorry about that. I think there was some connection issue.
No problem. No problem. Yeah.
Yeah. Sorry, I didn't realize I was speaking, and then I realized that there was some bandwidth issue.
No, I think we all will have to live with this, for several weeks and months. So
Egg,
it's absolutely okay.
it's
These are the
absolutely. Thank
glitches,
you.
which are part of it. Yeah, please go ahead.
Yeah. So the other thing that so what I was saying is that it's very important. I don't know how much you missed of what I was saying, but I was saying that it's very important for law students to find the right organization where to do their internships, right? In the first, because they're going to hit the ground running when they get into, when they start the first day of work, right? And there are enough of law firms today who give you good internship courses, who will take you, who will make you work on on live assignments, so you get practical training right off the bat, right? And so you're not going to be like me, where you go and you look at a lease agreement on the first day and you don't know how to review it, right? So it is very, very important, especially in the corporate world, where you're practically sound in how you're working, right? Even for us, when we recruit students, for of law schools, most of the times we recruit people who have already done their internships with us, because we know the caliber of the person, we know that they have been trained by us. And I suspect a lot of law firms do that, right? They do that. And especially today, guys, I mean, campus recruitments and all of that is not happening. It's not as robust as it used to be in these times. So the only way you can make your mark, or you can be seen and you can be noticed, is by doing your internships and doing them well, right? And uh, while your study and your law school and your principles and your analysis and your exercises and all of that gives you the grounding towards it, but if you want to be a proper transaction lawyer, then you've just got to practice. And I've been asked a lot of times, when I've been asked to mentor students, and a lot of them have asked me, do I do an LLM? Do I do something else, before I come and work? If you're interested in working and practicing corporate law, please don't waste your time. I mean, I will say this, I have said this every time, I have not changed my mind about it. Please don't waste your time, because if you want to teach, You want to be a jurist, you want to write, then please do your LLM, please do your PhD, please do all of that. It's all relevant. But if you want to practice and you want to be a corporate lawyer, I am not going to look at you saying, "Oh, you've done your LLM from here and you've come back," and I will still start you at level zero, right? Because your experience, you have no experience, and your experience is all that matters to me, and that is all that is going to matter to clients tomorrow, right? So, while I said, so the only way you can be a solution-oriented lawyer, you can be practical, you can be of service to your client, is if you understand the practices, the nuances, the actual, the live issues that a client faces when you start working. And no textbook, and I don't mean just here. Whether you go to Harvard or you go to Yale, no textbook will teach you these things, right? Real life is the best teacher. I always believe for many reasons. So I think that is something that everyone should focus on, and especially in these times. And I really I empathize, and I feel I understand the pain of what students today are going through in these uncertain times. Like pre-COVID, at least you knew you had all these campus recruitments, you could be placed somewhere. There were jobs that were much more. There were jobs that they are today, right? Because a lot of the firms have just frozen hiring. We don't hire anymore, right? We don't, we don't want to, we don't want to take on any more costs, right? But there are a lot of firms like ours, that give a lot of students paralegal trainings, right? Paralegal programs. So that what you say is you come in as a paralegal, the money is not great, let me be very clear, but you have a higher chance of getting absorbed within the firm a year from now. So that kind of thing. Now, if your passion is really to do law or practice law, please focus on that rather than how much am I going to get paid, right? Because I think that payment and all of that will come much later. And I think that, sometimes a lot of people equate corporate law to this glamour, sort of lifestyle, and this, oh, I'll get paid a lot of money from the get-go, and I'm going to be in conference rooms and I'll be talking and negotiating. No, please let me disabuse you of that idea. It's a lot of grunt work. It's a lot of late nights, early mornings. It's a lot of no sleep, especially when you're a junior, right? There's a lot of hard work that is put into it. But if you really love the practice, it's going to be so worth it as you go up the ranks, right? So it is a lot of investment that you have to do in the beginning, but it also gives you so much of understanding and knowledge. And like I said, corporate law, doing an M&A transaction, all that you can do is work at it, right? That is my biggest sort of guidance, if you will, on this. So, is there anything specific that I would like to listen to students? If they have questions, and I want. That's why I wanted it to be interactive. So, if there's anything specific that someone wants, I'm happy to talk a little bit more on that.
So I would request our dear friends in the participation, the ones who are attending the event. So please feel free. Either you can type it out in the chat box, I can read it out on your behalf, or I'll be happy to unmute you from my end, so that you will be able to yourself interact personally. And I would rather encourage that, because that's something that you can put forth your question by yourself. So I know some of my students are here online. So who want to interact and ask questions, please feel free. And it's because why I see it as a rare opportunity, I must tell you, Ms. Krishnamurthy, because when we have, I know there are a lot of my friends who are in my age group, they can probably spend more time, so bringing you, I know it's going to be a real opportunity for my students to come and speak with
Absolutely. I'm happy to talk to anyone.
Yeah. Please, anybody who you can probably raise hand or type it out in the Q&A section or chat box. Either of them is fine. We're looking forward to it. Okay, I have received one of the questions on the WhatsApp, because there are some of the law students who are watching it live streaming on the Facebook, that let me read it out to you.
Yeah.
Yeah, it is that what would you suggest to a law student that for somebody who may want to develop a practice in M&A, so should the law student begin with only going for all kinds of internships in general, or there is a definite sort of a path which a law
Yeah.
student should follow, probably from third or fourth year onwards?
Yeah. So I would say that, like I said, I think sometime earlier in the chat, in my conversation, I said that be very specific about where you want to do your internship. Don't be scattered, especially in your final years, right? Third, fourth, fifth year. Try and focus on those internships that you get in corporate firms. Also try and do your research on firms, because I know that there are firms, and I have frustrated interns who come, later and who intern when they come and intern here. And I've heard from them that sometimes, there are some larger firms where you will get your internship, but there will be no training, right? You're just sitting and you're researching and you're doing that. So just be absolutely sure where you're going. Do your research, do your homework, talk to your friends. There are enough of people who are doing internships today. And honestly speaking, check from them, and then then find your, find your groove or find your niche in where you need to go and work, right? But please do your homework before you start doing your internships, because that will be very important.
Okay, so there's one of our participants. Okay, there's one of my students from even the virtual law school. She is a student of the KIT law school in Bhubaneswar, for the degree purposes. She is asking that what are the risk areas which a transaction lawyer has to keep in mind in M&A transactions?
Okay, so 2-3 things, right? It's a very wide question, but and so the answer will be different if you're representing the seller. The answer will be different if you're representing the buyer, right? And the answer will be different if you're doing a joint venture collaboration. So for the purposes of this, I will just keep it very, very broad. Some of them may apply to both. Some of them may apply to only one part of the transaction. But I'll try and answer this question as best as I can. So the one thing that you have to first understand, the key risk, is that alignment of the objective. If the seller wants to sell, for example, let me give you an example. Let me just make it more sort of illustrative to you, okay? The seller only wants to sell business assets in the company, right? Doesn't want to sell the company per se. So I think all of you, I don't know how many of you in the fourth or fifth year, how many of you have done corporate law, but let me just see if I can simplify this. You have a company, it has shares, right? The company also has assets. So let's say the company has some industrial assets, some factories, some plant and machinery, right? Let's assume the company only wants to sell the assets, right? That is its plant and machinery, what we call a business transfer, right? That is also an M&A, that is also a form of M&A, but does not want to sell the company itself for whatever reasons. There are many, many commercial reasons. And like I said, Dr. Nachiketa, that would take an entire course to, get that going. So let's assume that they don't want to sell the shares in the company, they only want to sell the assets. The acquirer is under the impression that they want to sell the shares in the company, right? Now, there are two completely non-aligned kind of objectives, right? So this kind of transaction will not happen, right? Unless there is some kind of structuring, whether you say, okay, let me set up a special purpose vehicle, I will transfer this into that, and I will only buy the shares for kind of commercial. The reason I give you this kind of illustration is you as a lawyer have to first understand, one of the biggest things that you have to understand is what is the objective of your client. What is it that your client wants to get out of that company? Now, your client may go into it saying, I want to buy the shares of the company, but you may as a lawyer say, you know what you really want is that factory that is manufacturing those things. So it may be more economical for you to just buy that out. So let's structure this and buy that out, right? So you don't have to actually buy the whole company and get into that kind of sort of complication. Now, this is your job as an M&A lawyer, is to first identify what is the objective of your client, one, right? Second one is, once the objective is done, you then figure out what are the liabilities, what are my obligations as an acquirer, what are his obligations as a seller, right? So my obligations is obviously to buy, to pay the purchase consideration. He as a seller has a whole list of other obligations. He has to represent. He has to give a lot of representations to what he's selling. There may be some liabilities that he will have to continue to be on the hook for even after the transaction is over. So I might defer the purchase consideration. I might only give him part of it based on my due diligence. I will do a due diligence on the company. Based on that, there may be contingent liabilities. So the whole structure of the transaction has so many nuances. We, of course, talk about limitation of liability. We talk about indemnities. We talk about, if there's a dispute, arbitration. But remember one thing, the main thing in any of these transactions is that at the end of the day, you have to draft the document with the objective that it can get litigated. Because if there is no trouble between the two parties, nobody is going to open that agreement. That agreement is going to be in some cupboard. It's going to gather cobwebs, right? The minute there is a dispute between the parties is when that agreement comes out, and every word and every line is going to be analyzed, right? And sort of split and checked and, sort of argued about. And hence your drafting, the clarity of thought that you have to bring into the agreement becomes so important. And this is across the board, whether it is you're a seller, you're representing the seller, you're representing the buyer, your collaborators, joint venture collaborators, whoever it is, that becomes important. Is you look at worst case scenarios, no matter which party you are representing, what could be the worst case scenario and how do I address that worst case scenario? You have to think, that is your job as a lawyer, because tomorrow, if there is some kind of trouble, that agreement is what's going to protect your client, right? So I hope, like I said, it's a very, very large, a very big overarching question, but I hope I've been able to give you some clarity on it.
Right, thank you. So we have another follow-up question, which has come.
Yeah.
That how an M&A transaction for an unlisted company, how is an M&A transaction for an unlisted company different from that of a listed company? I know these are very open-ended kind of questions.
Yeah. Okay, guys. So unlisted companies are a little simpler. Listed companies are much more complicated. I'm being very simplistic in my answer, but listed company is there are more regulations. You have the listing agreement. You have to deal with SEBI, right? You have to deal with other regulatory authorities. You may have to even deal with the CCI, Competition Commission. You have to deal with, shareholders, because there are public shareholders. There's a public pool. You have to deal with insider trading regulations, because you have to then figure out, and then you have to deal with takeover code. You have to deal with that, because if you hit a certain threshold in a listed company, we've just completed a large listed company deal in the healthcare sector just a couple of months ago. Now, if you hit a certain threshold, you have to do an open offer to the rest of the shareholders. So a listed company M&A is much more complicated because of the various regulations that come into play, whereas a private company M&A is much more straightforward. It's more, okay, if I have to really simplify it and get it down to its essence, a private company as M&A is pretty much governed by the document, the contract, the shareholders agreement, the acquisition agreement, whatever you may call it, between the parties. Whereas a listed company is a large part of that is regulated by the various acts that I just mentioned to you, by the various regulatory authorities I've just mentioned to you, which have to be taken into consideration when you're drafting up the agreement.
Right. Okay, great. Yeah. So I'm sure, my dear friend, that you could take your input from that. And then there's a very interesting question, which I tell you, Ms. Krishnamurthy, even when I was in the National Law School, heading the internship and placements as a faculty. So this is a concern that I have seen the students' pain, actually being there, and it's a major concern. So that there's one student who is asking Ms. Ameya Kumar Pati that in most of the tier one firms, the students are asked to do research in various laws, but we seldom get chance to know about M&A transactions. So how should we make our way into that kind of a work? Is navigating through the law firm partners and associates. So I understand that's one of the very intriguing questions you would have also come across. So what would be a suggestion to the law students?
Don't be in such a hurry to get to the tier one law firms to do your internships. It does not always equate to a good internships. There are many mid-sized firms. There are tier two firms which will give you brilliant internships where you can do a lot of learning there, right? Which I would always encourage you to do your internships in a smaller firm, because you're actually put on live transactions, right? And you are learning there. So don't be in such a don't get carried away with a large law firm, because like you said, it's not necessarily that you will get the training that you think that you're going in for, right? So
Right.
that I can't say anything more on that, but that's all I can guide you. Yeah.
No, true. I agree that there's no rush, and it's good to start with sometimes the mid-sized law firms. And I have also been telling some of my students that it's like a preparation. If you have to run a marathon, you do not attempt for a marathon directly, right? So you start with taking a baby steps, and then you gradually prepare yourself. That probably after fourth year or so, you would have developed sufficient experience. Somebody who may even interact with you on a telephone to for the internship, so would be happy to know your insights. Then only your name tag or a branding you carry.
Now, let me give you an example of me. When I did my fifth year, when I did my internship, and in law school, fifth year, for the whole year, you had to do an internship in law school. That was your thing. Right. That's when I really got my training. Now, I did my internship in one of the old firms in India called Dua Associates, right? But though it was a tier one firm at that time, right? I did their internship in their Bangalore office, which is a very small office. Okay, barely 4 or 5 people in their office in Bangalore. And I did my internship there with them. And you cannot believe it, the amount of training and they put me on due diligence exercises. I didn't even know what a due diligence was, right? And I actually got to work on actual live due diligence exercises, right? And that's when I realized the value of working in a smaller group, in a smaller thing, because they're almost using you as a lawyer. They're not using you as an intern. They're using you as part of the, legal team, because they're a small group. So that's my suggestion. That's my advice to students who really want to learn something.
Right, true. Ms. Vishali, your question is answered, that what should be a thought process required, and what would you suggest to a fresher with relevant internships? So that's what Ms. Krishnamurthy was answering all about. So I'm sure you would have taken your input from there. So yeah, we have another interesting question. That while negotiating on indemnity, representations, and warranties provisions in transaction documents, both sellers and buyers, legal advisors reach a deadlock, and it ultimately goes back to the principles for the consideration. Any tips or tricks based on your rich experience to have an upper hand in such negotiations?
Yeah. So this is where you come in as a star lawyer, right? And this is how you kind of get the edge over your competition, right? What I've always done is, if there is a deadlock, right, where we've negotiated, I will go to my client with a solution. It may not. So therefore, this is exactly why I started by saying, you are a commercial lawyer. You're not a legal lawyer. There's a difference there. You are a commercial lawyer, by which time you are so deep into that transaction, you understand the nuances of the transaction, and you're able to get a sense of the commercial considerations that are at play, right? So how will you, and even today, I think that is why my clients, I have very loyal clients over the years, is because I will go to the client and I'll say, hey, this is the solution. Give this up. This will have no teeth tomorrow in law. This is all very academic, but take this, right? And I will stand by that. I will not allow my client to take on the burden of saying, oh, should I make this choice? Should I not? Because you have hired me for this purpose and this purpose only, is to ensure that you close this transaction. Right. And also remember one thing, it's very important that you guys know, is that as M&A lawyers, we are not in an adversarial system here. We all have a common objective. Please keep that at the back of your mind. You're not in court, you're not litigating, you're not arguing, you don't have different interests, you don't have diverse interests. Your client and the other person's client have the same interest. I want to sell, he wants to buy. We have the same objective, we want to get the deal done. I always tell my clients that if a lawyer doesn't let the deal happen, there's something wrong with that picture, right? Because the main work, all the grunt work, the pricing, the commercial, all that has been done by the principals. They come to you to hammer out the deal, to ensure that everyone's rights are protected and the deal is closed, right? So you can't be an obstacle. You have to be a deal maker. You have to be a deal closer, right? You can't be a deal obstructor. So this is where you come in as an edge. You come in, you tell the client, hey, you know what? I think this is what we should do. Let's give this up. You take a call as a lawyer. But let's insist on this. So there's a bit of give and take, right? And if there's a give and take, in my 24 years of experience, I have never seen a deal not close, right? Because both parties want to do the deal. They've come to that stage where they both have agreed to do the deal. So unless there's something commercially that's found later, they don't want to not do the deal, right? And remember one thing, if you're going to be high-handed and have your ego at play in the negotiations, or you're trying to show off, because I say all this because I've seen all this across the table, right? Please understand, clients will midway they can change their lawyers. I have seen that also happen. Midway they will change their lawyers. So please go with the intention of saying both of us are on the same side. You put your ego aside. Doesn't matter how the other person is reacting, but you go with the only purpose of closing the deal, and that's how you get your edge.
True, I really understand that, and I am sure students would also take it, as a positive feedback, that you need to sever through that kind of work that you would do in the litigating law firm, and that Ms. Krishnamurthy is talking about that you would do in an M&A law firm. That you have to leave your black gowns of a litigating lawyer outside the law firm when you do the M&A work. So it's not pitching one against the other. So you're working towards a common objective here.
Absolutely.
Right? To find a solution. I really take that as a very good piece of advice, somebody simplifying it in such a way that as a lawyer, kya nahi karna? It's that kind of thing. You're all doing
the same thing. You're working towards the same purpose. I think sometimes we forget that when you're doing an M&A transaction. It's the same objective. It's not different interests.
True. Right. So thank you so much. That's been a very good takeaway and advices that you have given to our law students and some of the young lawyers whom I know are attending here. Some of them who have also done their masters from Jindal Global Law School and abroad. So there's one more question which has popped up. If you have 5 minutes, we'll take it up. And
No, I have time. I have another 15-20 minutes.
Oh, good. So this is another question which is coming up here. What should be the best approach for a lawyer to decide upon the dispute resolution jurisdiction clause under the transaction documents? There are different school of thoughts where some consider having Indian courts their jurisdiction, and some consider having SIAC or foreign arbitration seat for dispute resolution. So how would you give your input on that?
Okay, I would say that today our Arbitration Act is not a bad act at all. I mean, there is now a time limit within which you can actually close arbitration cases. Always, I would say, opt for arbitration under a contract. First off, opt for arbitration. If both parties are in India, there's no need for you to go to SIAC or to London arbitration or any of that. You can do it in India. We have great arbitrators. We get good arbitral awards. They are savvy. They are sophisticated. There is nothing wrong with our arbitrators. If both parties are in India, the company is in India, and you know why? It's just easier to enforce that award here, right? Now, if the parties are abroad, or if one party is abroad, and the company is abroad, that's a separate thing, right? Then you look at whether it makes sense, whether it's Singapore arbitration or it is London arbitration or whatever it is, right? You have to. So it's very situation based. But if both parties are in India and the companies in India, the acquiring company or whatever it is that you make, or the target company, I would not think of doing it anywhere. And also, please understand, SIAC in London is very, very expensive. Arbitration costs are very, very expensive. And if I don't see the point of it. I don't see what the edge is if everyone is located in India. So my advice to clients is always just choose arbitration in India.
Sure. Okay. Yeah, so there was another question that appears to be repetitive. We'll not take that up, about the law firm internships. Yeah, so I think, most of the questions that were there in the Q&A and chat box we have covered. There were a couple of questions which were of the same nature that you've answered already. So that was it. If my dear friends, you have anything else, so take another minute and so. Maybe you can use your mic.
I think there's one question. Somebody has said, what kind of thought process is required and what would you suggest if a fresher with relevant internship?
Yeah. So that's what I was thinking, that you've touched upon that. But if any more thoughts to add, you can certainly tell us.
Is willing to practice M&A independently as a litigator. I did not understand that. Can the person speak and just clarify the question? Is that possible?
Yes, yeah. Ms. Vishali, you probably need to, add more light to your question. That what do you want to specifically ask? That
independently as a litigator. Yeah.
So probably, as I can only try to gather from it, is somebody wanting to ask that if you're a fresher, so how should you go about it? That's the reason I thought.
So it says is willing to practice M&A independently as a litigator. I didn't understand what is M&A and litigator. It's not. I have not understood what that question is.
Yeah. So we probably ask the author of the question to specify, then we can take it up.
Yeah, if you clarify, I'll be happy to answer your question. Not a problem.
True. Yeah. Anything else, my dear friends? Feel free, and then we can take it up. We have another minute to add there.
The other thing that I would always say is that please be open to learning, because there is no end to the amount of learning that you can do in a situation like this in corporate M&A. Because the other thing that is beautiful about M&A transactions is that every M&A transaction is different. There are so many different nuances that happen in every M&A transaction. I mean, I have practiced for 24 years. And if you ask me to say, which are two M&A transactions that are similar, I can't find. And it's not the legal structure. It's not that, will I acquire 100%? Will I acquire 51%? Will I acquire 26%? Because that also has its different dynamics on how much you're acquiring in a company. But it's the fact that, it's different businesses. There are different interests. There are different dynamics between the seller and the buyer, right? I have sellers who have actually, lost their cool and walked out of the conference room saying that how dare, because we have a clause, we have a standard clause in all our M&A contracts, which talks about fraud and willful misrepresentation, right? If there's fraud and willful misrepresentation, you have unlimited liability, right? And he said, how can you say I'm fraudulent? How can you say I'm a fraud? He took it personally, right? Now, that's the beauty of M&A transactions, because at the end of the day, you're dealing with people, you're dealing with different personalities, right? And trust me, those personalities have their own, nuances about it, right? So I think every M&A, and that's the beauty. I also do a lot of private equity transactions, right? I mean, when you say corporate, I also do a lot of private equity transactions, but I prefer M&A transactions because private equity transactions are pretty much standard, right? You have it's a financial investor who comes in, who acquires the company for a limited period of time. There are, exit clauses, there are IRR clauses, there are his standard, sort of reps and warranties, his protection, and then his liquidation preferences, and he leaves, right? After 5 years, 7 years, whatever that, that horizon is. So private equity transactions are pretty much, one is similar to the other, because the interest of the investor is only as a financial investor. Whereas an M&A transaction is you're coming to acquire the company, you're a strategic collaborator, you used to be a competitor of the target company, or you are acquiring this company to complement your business already, or for what many reasons. So therefore, an M&A transaction, every M&A transaction is so unique in itself. So that's why I say that the more you work, the more you learn out of these transactions, the more experience you will have.
Right. Okay. Yeah, so I think, Amir, you have a series of questions which, I would rather encourage, some of the other participants to bring to the table, because, I do appreciate your concerns, and but surely there are a few other friends. For example, one of my students here in the Q&A different box has posted, is it a good idea to intern in M&A firm if you have a very little knowledge of the subject in the initial years of law school?
It doesn't matter. Which year are we talking about? Second year? First year?
Yeah, as much as I presume, like second and third year. That's what the students.
I would always guide you to start working in M&A firms in the third year onwards, because by which time you have some grounding, you have some basis. Because what happens is in the first and second year, even if you come in and work in an M&A firm, your grasp of what is being told to you, you will not have that, the clarity of understanding, because you would not have done those subjects, right? Companies law. I don't know, companies law, do you do it in your third year or in your second year now?
Mostly third year.
Third year, yeah. So nothing has changed from my law school days. Yeah. So I would say, because you won't even have the basis of that. What are shareholders? Who are the directors? What's the relationship between shareholders and directors? What is directors' liability? What is shareholders' liability? What is the company which is separate from shareholders and directors? All of those things make a lot of difference in your M&A transaction, right? So if you don't even have that basis, that grounding, you will not understand or appreciate or even retain if you're actually doing an internship. I hope that makes sense, right?
Yeah, right.
So I would always encourage you to do it from the third year onwards.
True. Okay. Yeah. So as we are heading towards 6 o'clock, there's probably the last question we can take from Shikhar Tiwari. Ma'am, Facebook acquired WhatsApp and Instagram in India. Why is the cost not seen as a violation of abuse of dominant position and try to monopolize this social media industry?
Sorry, what was that? Read that question out again.
Facebook acquired WhatsApp and Instagram in India. Why is the act not seen as a violation of abuse of dominant position and try to monopolize social media industry?
Because they're different. They're different platforms, right? They're different platforms. So you have I understand exactly where you're coming from, but there are different platforms. And I assume I was not part of that transaction, but I'm assuming they got CCI approval, right? They did get the CCI approval. For whatever reason, they got the approval. So they did it. So for me, the thing is that I agree with you that it is an abuse of dominant position. I personally agree with you. But who's to say how they have spun it? There are different ways to spin the same thing. And there are different platforms of the social media, right? So, and that's how it has come to pass. Right. And remember that the acquisition, happened in the US. Right. The acquisition has happened in the US, and then the fallout has happened in India. Right. So that you have to keep that in mind. Right.
True. Yeah. There's so many dimensions to anything, that we cannot simply put it in black and white for the purpose of answering, and especially without knowing so many nuances, which would have led to that sort of arrangement actually coming up, and different transactions, different kind of.
And I will say this, that if you have already done the main acquisition of the parent company in the US, right, it's little difficult I mean, unless you have a really, really strong case for India to sort of prevent that transaction from culminating with its, sort of companies within India, the affiliated companies in India. So, there are so many different ways, but again, this is a discussion in itself.
True. Definitely. So, Shikhar, and all the students, whenever we look at some of these problems, we do face some of these situations in the classroom when we teach. So, my advice from the academic point would be that, you must try to get all the facts together, and then only you can very appropriately look at them and try to see that which law is going to be applicable in terms of probably precluding such a kind of thing and maybe allowing it. Right, so it cannot be a straight jacket formula attached to every kind of a situation.
Yeah, I agree.
Yeah. So thank you so much, Ms. Krishnamurthy. It was pleasure, hosting you today as part of our very premier global legal and approaches development talk, where we are hosting most of the industry leaders, as you know by now. And it was also my pleasure, and I would like to thank Mr. Alok Sonkar, who's been my dear friend, and who has got me in touch with you for the program. And also Ms. Rohini from your office, your colleague, with whom I had several back and forth emails for several weeks. So, and it was also a pleasure, like last year, hosting Ms. Aditi Mittal from your office, your colleague, who came to judge the moot court competition in Gandhinagar.
Yeah.
So that's why I recall my association in that sense, and I could pay a visit also in December last month to your office. So it's been a good sort of knowing you, your friends, your colleagues. And in fact, I was speaking to some of the corporate lawyers, even in Ahmedabad last week, for example, Mr. Pankaj Agarwal from Shardul Amarchand and Shroff. So, for example, he said that, yes, I'll be happy to also attend the program. So there's so many friends who have messaged me about, that, you could get Ms. Krishnamurthy on board for your talk. So that's a good thing forward. So
for me, I think my passion is about education, and it's about, just making sure young kids today are prepared, are equipped for the world ahead, because, the world is not always very kind or doesn't go the way that one would like it to go. So I think, and I always tell my lawyers in the firm too, that remember that your interns and paralegals and first year associates, they're the most fragile of the lot, right? They're the most fragile souls, right? So be very careful in the way you talk to them, the way you treat them, because, they're just coming into this world, they don't know what's, they will develop a thick skin a few years down the line, but for now, keep them safe and keep them protected. And I think that's why I was very happy to be part of this talk, because I always, if there's any chance that I miss my calling. I should have been teaching, but
for a lecture someday.
Sure.
And I take it also, as reconnecting, for example, in that sense with my senior colleague in you, as a law school alumni, since we've been the batchmates in law school Bangalore. So for me, it's in that sense of connecting with a senior colleague too. So thank you so much for giving your time. And I'm sure that the lawyers and young law friends would have taken the, inputs, and there've been so much of a question and answer session. And there was, I would say, quite, bombarding with so many live queries. It was full of excitement in that sense. So have a good day. And everybody else, all my participants and friends, lawyers, students, be safe. Take care of yourselves. And we'll be coming back the next global legal and approaches and development talk on virtual courts and settlements in these days of new normal, from Professor Benjamin Davis, who has been also an arbitrator and a professor in Toledo University in Ohio. So stay tuned with us, and thank you for your blessings and support.
Thank you for everyone, and stay safe. Thank you so much.
Thank you.